The entry of a criminal conviction may have repercussions that most of us never think about. We'll talk about a criminal's civil rights right now on the Law Works.
From West Virginia Public Broadcasting.
Closed captioning for the Law Works is made possible by a grant from the Monongalia County Bar Association to support legal information and education for all West Virginians. The Law Works is made possible by major grants from the Office of the West Virginia Attorney General and from Software Systems Incorporated, a West Virginia company established in 1975 which provides high-end support services, programming, and consulting for county government AS400 mid-range computer systems, as well as PC-based systems, and by a grant from the West Virginia Bar Foundation. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system, promoting public knowledge of the law in West Virginia.
If you're convicted of a crime, you may lose more than just your freedom. My guests are attorneys George Castell, Kanawha County Chief Public Defender, and attorney Brian Kornbrath, Chief Federal Public Defender for the Northern District of West Virginia. Gentlemen, thank you for joining us.
Thank you. Thanks for having us.
You lose civil rights because you're convicted of a crime? I thought civil rights were inherent, that they were yours by act of God.
Not God, but certainly your state constitution and your federal constitution, as well as various statutes that apply at both levels.
Why do you lose them? How do you lose them?
Some things disappear when you say the word guilty or when the jury pronounces the word guilty. And there are a long list of things, including voting rights, rights to possess a firearm, rights to serve on a jury, rights to lots of occupations in the state of West Virginia.
Well, it recently came to my attention through the media that this being an election year in which we're talking, that not everybody can run for public office if you were convicted of something, but what can you not run for? Well, I guess running for public office and holding public office are two different things. You can't hold a public office.
Right, right. And we have to preface our remarks with the warning that every state is different. West Virginia is not going to be the same as Ohio or Pennsylvania. So I think it behooves everyone to approach the Secretary of State office in each state and see if you can get specific information for where you live. Much of our conversation, I think, is going to revolve around what happens here in West Virginia, but it's very specific in regard to the state constitutional provisions, the state statutory provisions, and then any case law that the courts have issued that shed light on those protections.
So it's not the same everywhere. Is it the same between state and federal crimes?
Well, I think the demarcation is felony versus misdemeanor. Many of the civil rights are removed permanently if you have a felony conviction, which is any criminal offense that carries over 1 year in jail.
And most are removed permanently, but not all. For example, the right to register to vote and the right to vote lasts in West Virginia only as long as the sentence is being served or any period of probation or parole is being served. Once the sentence has been served and is complete and the person is released from any supervision, their right to register to vote and their right to vote is automatically reinstated. And they don't have to do anything to get it reinstated. Once it's over, they're eligible to vote.
The right to vote.
Yes, and that's really poorly understood. I think there's a public perception, and even a perception among those of us in the legal community, that upon being convicted of a felony, the right to vote is permanently barred, permanently removed. That may be true in some jurisdictions. It's not in West Virginia.
You said even among us lawyers, and I find that especially true. I can't tell you the number of times I've stood in a federal courtroom where the judge is rather laboriously reading out the things that's going to happen to the defendant who's just pled guilty, says, or pleading guilty, says you're going to lose your civil rights, you're going to lose the right to vote, you're going to lose the right to hold office. And we never question those things. It's a federal judge telling us that you're losing civil rights. But it wasn't that clear cut. You mentioned actually several kinds of punishment. Being in prison is one thing, being on probation is another thing. In the federal system, there's yet another thing called supervised release.
Correct.
Now, when do you get to start voting again? When you get out of prison, when you come off of probation, or when you're off of supervised release? And I'm willing to bet that we don't know the answer to that question off the top of our heads.
Well, we don't, but in preparation for today to appear to be as knowledgeable as I can, I think Brian and I have both reviewed those concepts, and as I understand it, by rulings of the West Virginia State Supreme Court, once any supervision ends, once the supervision is over, the right to register to vote and the right to vote is restored automatically.
So, Brian, would that mean supervised release?
I believe so. And when George says automatically, nothing has to be done. You don't have to go and fill out a form and request the right to be reinstated. It's there as a matter of law, and that's important here in West Virginia.
Who enforces this?
I believe the Secretary of the State would be responsible for confirming that a potential voter has the right to cast that vote.
Who tells the Secretary of State that I, for example, can't vote? I can, but we're role-playing.
Well, she watches this program.
But the fact of the matter is there is a voter registration list, but it is not well tended, I suspect, because of the size of it. The judge doesn't pick up the phone after the sentencing and say, okay, take Brian Cornbrath off the voters registration list, I just sent him to prison. Or does he?
I don't believe so. I mean, if someone wants to confirm that he or she has that right to vote, you got to, go and check on it, meet with the officials from the Secretary of State's office. But at least here in West Virginia, it's an automatic occurrence. I mean, again, no forms to be filled out. You have that right to vote again.
You're kind of on your good behavior.
Yes.
I guess the clerk in the county that you're registered in, if he or she gets a request from you and for an absentee ballot and say, I'm out of the area, I need you to send an absentee ballot to me at Mount Olive, West Virginia, which is where the federal or the state penitentiary is, that might be a tip-off, or I need you to send it to me at Hazleton in Preston County.
Might raise a red flag, but one of the reasons that these questions are difficult to answer is because practices vary from time to time and from county to county. The voter registration officials in one county may choose to be vigilant, or party activists may choose to be vigilant and try to confirm that people are registered or properly registered, or people applying to register or have proper applications. And some may not, and it changes over time. So in order to say whether a person is going to be purged from rolls upon getting a felony conviction or would just be committing a violation if they show up and vote and hope to get away with it, whether they would or not, I mean, it's all difficult to say because practices change over time, enforcement policies change over time, and they vary from county to county. So all we can say is, or all I can say is as a generality, that it's illegal for a person under a felony conviction who hasn't yet completed the sentence or a period of probation, parole, or presumably supervised release. It's illegal for them to vote.
We should mention we don't have supervised release in the state system in West Virginia. You finish your sentence and your probation, if there is any, and then you're done. But in the federal system, you can be subject, after everything else is done, to a term of supervised release, which is basically a very loose form of probation, just so the probation officer checks in, or you check in with him or her every once in a while, make sure things are going all right and that you're not involved in something or with somebody you shouldn't be.
Correct. It allows for transition back into the community with supervision from probation. And if there is a serious violation, you could actually go back to prison for that violation. So it's a carrot and a stick.
And in practice, for federal prisoners being released on supervised release, it must feel a lot like state prisoners being released on parole. The terminology is different, the structure is different, but the sense of it is the same.
Yeah, and I've always kind of viewed supervised release as an opportunity to help in the transition back into the ordinary community, because there's somebody there. If you're having a problem, you can call them, you say, I need help with this, and much to some people's surprise, there is some help available, not as much necessarily as we'd like to have. We're talking about a criminal civil rights. My guests are Attorney George Castell, Kanawha County Chief Public Defender, and Attorney Brian Kornbrath, Chief Federal Public Defender for the Northern District of West Virginia. I'm Dan Ringer, and this is The Law Works. The interesting thing about voting, if you're not allowed to vote, is no one may catch you at the time, but it's still a crime, and when someone goes through to purge voter registration lists later on, or as we suggested, a party activist or a voting activist comes in to review the records and they find that you have voted when you were not allowed to, you can be prosecuted at that point for having committed yet another crime and be punished for it. And if you're still on supervised release or probation, just really on short notice, find yourself back in jail.
Absolutely, it would be a new crime, and and your voting record is a public record, so that the law is enforceable, it's on record. You just can't do it, that's all.
We certainly don't want to act intentionally to violate the law. I mean, check with an official who has the final say in the matter. I mean, go to the Secretary of State's office and get an advisory opinion before you cast that vote. I think that's the safest call.
Yeah, you may ask yourself, what is all this hullabaloo about voting? One vote isn't going to make any difference. Yes, it might. And I frequently tell this story. My wife and I moved in to a new home in a town in which we had not resided previously, and it was a city council election. And we looked at the list of candidates and we said, well, we don't really know anybody. We know this guy, but we're not going to go vote in a city council election where we would only be voting for one person, and we were really not too sure about many things. So we didn't vote. We didn't particularly like the guy that was on the ballot, but we didn't vote. He won the nomination to run for city council by one vote. Small town, but one vote made a difference. So the general election came up, and we looked at it and said, you know, the last time we could have determined the outcome of that election, we're going to go vote this time, so we went to vote. Our candidate won by one vote. The fact that my wife and I voted or did not were determinative of the outcome of 2 consecutive elections. We vote now. We're afraid not to vote.
It's an important constitutional right, so it's worth looking into. I wish I could say the right to sit on a jury was as up in the air, but it's not. It's very clear-cut at both the state and federal levels. If you have a felony conviction, it's a lifetime prohibition. You simply cannot sit on a jury, grand jury or petit jury.
Well, at the risk of being obvious, why not?
Well, that's a problem, and it's a problem with, to me, it's a problem with all lifetime disqualifications, including, a list of professions, a list of occupations that require professional licensing. What a 19-year-old does is sometimes very foolish, sometimes very impulsive, sometimes even cruel and deserving of punishment. But what a 19-year-old does as a 19-year-old, and what that same person, who he is and what he does or she is and what she does as a 30-year-old or a 40-year-old or a 50-year-old is very different. And for somebody to be disqualified for life for an act, an immature act by a very immature person, is, especially when felonies in the state of West Virginia are defined as what to you and me are relatively, some of them are relatively minor acts. Just as a matter of policy, shouldn't be a lifetime ban. It creates what some people have described as a permanent underclass. We're trying to, the best way, one of the best means of rehabilitating someone is to have them participate fully in the social and political and democratic process. So the lifetime bans, I think, are just as a matter of policy are a mistake.
Well, you're one of those bleeding heart liberals, I guess, that
Yes.
people describe. What happens to the concept of paying your debt to society when we have lifetime bans on what we label as rights. I mean, if you've paid your debt to society, you've paid your debt. Why do we continue to punish you?
Well, technically there is just one possible way to get some of the rights that you've lost reinstated, and that's through pardons at the state and federal level. On paper, it exists. In reality, they're so few and far between, they're almost not worth mentioning. It's very rare for either the President of the United States to pardon someone who has a federal conviction or the governor of a state to pardon someone that has a state conviction. It just doesn't happen in practice, but it's technically there.
Well, we've seen, it seems like at the end of every elected term of a president or a governor, pardons are issued. And there's usually in the media a particular examination of who the people are that have been pardoned, and you have to be pretty well connected to get a pardon. I have only seen one in the time I've been practicing law. The gentleman got pardoned had been convicted of rustling when he was 18 or 19 years old. He had some explanations as to how he got wrapped up in that, but he was convicted of it. He served a year in a minimum security facility, went out afterwards and became a very successful business person, was a strong asset to his community, did lots of good works during his life, and at the end of a particular governor's term, he had contributed the right amounts to the right campaigns, the right people, and the right people asked the governor for pardon, and the governor's last act in office was to grant it.
Well, aside from the political contributions, the financial contributions, I think every other ground you mentioned is a ground that should be the cause for a pardon. It just should apply across the board to everyone in that position, not just those who have contacts and connections, but the person who struggles at a low-paying job all his life and for whatever reasons, just misfortune, maybe should have the same right to rebuild his life as a person with political connections. I just wish that the pardoning and commutation process applied across the board at all social levels and was judged on a case-by-case basis and not seemingly handed out in those instances you mentioned.
Political favoritism.
On the basis of political favoritism. But the example you mentioned is something, take out the political favoritism, the pardon should still have been granted because of the lifetime of rehabilitative good acts.
But if he had been a person who had unloaded boxes from the truck at the big box store and had done that all his life.
Should be just as eligible.
He should have been, but we know that he would not have been. We're talking about a criminal civil rights. My guests are Attorney George Castell, Kanawha County Chief Public Defender, and Attorney Brian Kornbrath, Chief Federal Public Defender for the Northern District of West Virginia. I'm Dan Ringer, and this is The Law Works. Professional licenses. You lose your right to a professional license if you're convicted.
That's a tough one. And the reason it's a tough one is that it seems when I review the licensing requirements, they seem to be different for almost every profession. So some have exceptions, some don't. Some can be waived or overlooked on a case-by-case basis, some can't. So if a person's interested in a particular career, and I'm including barbers, beauticians, engineers, lawyers, pharmacists, every occupation that requires admission through some professional licensing board has standards. Most of them automatically disqualify anyone who's been convicted of a felony, comma.
However.
And then for each specific profession, there seems to be at least the possibility of exceptions made on a case-by-case basis. And that's probably as it should be, because some felonies are really severe and maybe should disqualify that person from pursuing that career. Others are things that after 5 or 10 or 15 years of successful treatment and rehabilitation and people ought to be able to pursue those careers on a case-by-case basis. So the licensing board should have that flexibility. In some instances they do, in some instances they don't.
In some instances, it's discretionary, and if the composition of the licensing board is particularly difficult with regard to the licensing issues, you're not going to get your license, or you're not going to get it back. The toughest board, in my experience in West Virginia, to ask to get an exemption or some special consideration is the Board of Nursing. If a nurse gets a DUI conviction or gets caught for some other maybe non-nursing related criminal activity, she's out or he's out, and they're not going to get back in.
Okay for the physician, okay for the hospital administrator, okay for the lawyers representing everybody in the process, but not okay for the nurse. It sounds a little unfair. I don't mean okay, but at least
They have
can be reviewed.
exceptions.
Sure,
yeah. Board of Medicine, licensing a physician. A physician can have a serious drug addiction, but if she goes and gets the proper treatment, the proper rehabilitation, we'll call it, even though the felony conviction for the drug matters exists, they can still continue to practice medicine under some circumstances.
And with the proper supervision, they can lead productive, helpful lives. It doesn't make sense to strip a license from somebody who, it's taking a person at the lowest point in that person's life and just driving them lower if you forever prohibit them from redeeming themselves and restoring their dignity and self-respect and earning capacity. So I totally agree with the flexibility.
But it goes back to what we were talking about before as to your position in society. It doesn't seem like it should, however. If I'm drug addicted and I get convicted of a federal crime and I work at a service station fixing automobiles, assuming I had to have a license to do that, I would probably be out of that profession. But a physician with a drug addiction is still a valuable tool in the healthcare industry. She can still practice medicine, she can still help people. The special consideration is she can't have a license to write prescriptions for narcotics.
Fair enough.
We can't give clear answers to every occupational question out there, but I think what the public has to understand is don't think you can't pursue that line simply because you have the felony conviction. There is a licensing board, there is an administrative board that has some discretion to give you that opportunity to work in that profession regardless of the felony conviction.
As I promised before we started this show to you folks privately, we've got a couple of minutes left. Now let's talk about firearms. If you are convicted of certain crimes, you lose your right to possess firearms.
Correct.
What?
At the federal level, a felony conviction removes the right to possess firearms, as well as what's called a misdemeanor crime of domestic violence. If there's any violence within a personal relationship, spouse, significant other, boyfriend, girlfriend, that misdemeanor conviction as well requires lifetime prohibitions against possessing firearms.
Is that true at the state level?
Well, yes, but also at the on the state level, we have to include mental health commitments, because if somebody's involuntarily committed, and there's hundreds a week in this state, thousands a year, they too lose their right to own and possess a firearm. And in a lot of rural areas of the state where hunting is a revered family cultural tradition, it's a big deal.
Can you get your right to possess firearms back in the state of West Virginia?
You can petition to get it back, and the judge reviews the petition. It's a difficult process, and you have to provide a lot of documentation that in support of the petition.
Is that the circuit court, George?
Yes, yeah.
Okay.
And then in the state court system, it would be the circuit judge, the judge of trial court of general jurisdiction.
But domestic violence convictions are state convictions. Now, you said in the federal system, a domestic violence conviction, you can't get your firearms back, your right to possess firearms back.
That's correct, right.
So even though you have your right to possess firearms restored at the state level, can you petition to get the right back in the federal court?
If you have a federal conviction, not a state conviction, because the state of West Virginia cannot reinstate the right to possess firearms for a federal felon. At the federal level, if you have a federal felony conviction, on paper, there's a statute that allows you to go to the Bureau of Alcohol, Tobacco, and Firearms and ask for your gun rights to be reinstated. In practice, they're not processing these applications. Congress has actually said to ATF, we're not going to fund you to do this. So in reality, if you have a federal conviction, the ATF is not going to process your application to ask for the gun rights to be restored.
So you have a right, but the system just doesn't work.
No, there's just that one niche in the system, and that's the full presidential pardon, which would reinstate the gun rights as well, but that is so few and far between.
George Castell, Brian Kornbrath, thank you for talking with us.
Thanks for having us.
Thank you for being with us. On behalf of the LawWorks, I'm Dan Ringer. Good evening.
If you would like to suggest a topic for a future The LawWorks show, or if you're a school teacher and would like to receive a DVD of this show for classroom use, send us an email to thelawworks@comcast.net or visit us on Facebook. On the LawWorks website at thelawworks.org, you'll find a listing of recent The LawWorks programs, additional information about this show's topic, and video of this and recent shows. You can also find the LawWorks programs on YouTube and iTunes.
The LawWorks is produced in cooperation with the Office of the West Virginia Attorney General, the West Virginia Bar Foundation, the Mountain State Bar, the Monongalia County Bar Association, and the West Virginia University College of Law. The LawWorks is made possible by major grants from the Office of the West Virginia Attorney General and from Software Systems Incorporated, a West Virginia company established in 1975 which provides high-end support services, programming, and consulting for county government AS400 mid-range computer systems, as well as PC-based systems, and by a grant from the West Virginia Bar Foundation. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system, promoting public knowledge of the law in West Virginia. Additional support for the LawWorks is provided by the West Virginia Supreme Court of Appeals.
From West Virginia Public Broadcasting.